free.
Oh, whoa. So even worse, she had a 13-year-old blow into the machine? I don't know which is worse. You telling me that, yes, is that what I did, or you lying to me?
And Lori Yaki, Assistant Public Defender, with and on behalf of Ms. Threet, who's approaching. Ms. Threet, could you say your name for the court?
Bachelor Threet.
So, Your Honor, within the last couple days, Ms. Threet has sought an assessment for treatment. She completed the assessment. I have the paperwork here. I have the letter here. Based on the assessment, she's been recommended to participate in the intensive outpatient program through Henry Ford Health. Going to have this documentation here. She is scheduled to attend individual treatment on the 2 days that she's not doing her intensive outpatient program, which is scheduled for 3 days per week. Additionally, Ms. Fleet is doing meetings every single day as a part of her recovery. I would ask, Your Honor, obviously the bond violation is very concerning, it's very serious.
Okay, yeah, go ahead. I'll listen to everything, but
I would ask if the court would consider converting her Soberlink to a SCRAM tether to ensure that she's getting 24/7 supervision monitoring to ensure she's not drinking.
Jackie, you do realize that not only did she blow numbers, but then decided to have someone else blow into the machine for her.
Yes, Your Honor. There's no minimizing. There's no excuse or justification. The only thing I can do is present our plan moving forward, which the therapist has a psychiatrist. She does have mental health diagnoses. So she does need medication. She has her psychiatrist she's working with. She has her therapist she's working with. It took her a minute to find the right treatment to address the needs that she has. She is a single parent of 2 kids. They do rely on her tremendously. One is 3, one is 13, I believe. And
So even worse, she had a 13-year-old blow into the machine?
Well,
I didn't ask her to. She's free.
Oh, whoa. Is that what happened? Be careful how you answer it. I don't know that there's a good answer, but you better be careful how you answer it. Because I don't know which is worse. You telling me that, yes, is that what I did, or you lying to me?
I at this time, Your Honor, I'm asking if the court would convert her to a SCRAM tether and mandate that she
drank and then had a child blow into the Soberlink.
I understand that's what the violation report says, Your Honor. And
does she admit to that violation or not? I mean, if she wants a hearing, we'll have a hearing.
This is a crucial procedural moment. Judge Simpson is separating an alleged bond violation from an admitted violation. The report claims Ms. Threet drank alcohol and then had her 13-year-old child complete the confirmation test, but the defense has not formally admitted those allegations. That is why the judge offers a hearing. Before the court makes a final factual finding, the defendant has the right to contest the violation and require supporting evidence. The defense also faces a serious credibility problem. Requesting stricter monitoring and presenting a treatment plan may show an effort to address the alleged substance use problem, but neither measure explains the apparent attempt to defeat the existing monitoring system. A SCRAM tether could provide continuous alcohol monitoring, yet Judge Simpson must decide whether any technological safeguard can compensate for deliberate circumvention. Notice the warning to be careful when answering. The judge is signaling that an impulsive admission could establish the violation, while a denial inconsistent with available records could further damage credibility. Would you admit the conduct and focus on mitigation, or demand a hearing and force the prosecution to prove exactly who used the device? That strategic decision could determine whether treatment remains possible or detention becomes unavoidable.
I understand. May I have a moment to... verify with her, Your Honor.
Yep.
Your Honor, may we briefly approach?
I don't know what good it's going to do, but you can come on. Record should reflect we've had a bench conference in this case. You're supposed to say, Michelle.
The only other thing I wanted to request that I forgot to mention at the bench conference is if the court is inclined to revoke her bond, I would ask if there's any chance the court would allow her to be released to an inpatient treatment program with the tether, as clearly the root cause of both the underlying case as well as the bond is an issue of substance use. Again, she has dealt with enormous trauma. She's a survivor of domestic violence. She left an abusive relationship where her ex was convicted. And I think in November or shortly before December, which is the alleged offense date here. So there's a lot of circumstances surrounding here. Understandable that the court and the people are concerned for the community, but I would ask that this not be a case just held in jail without the opportunity to get inpatient treatment.
Ms. Feltes.
Your Honor, the people at this time would request the court revoke the defendant's bond and do not grant her a release to treatment. The underlying offense in this case is an operating while intoxicated third offense. Her priors are from 2011 and 2016. In this case, there was more than one call to the police reporting the defendant's bad driving behavior. She was eventually located by Michigan State Police troopers, crashed. And when they had contact with her, she admitted to drinking. Eventually, a search warrant was obtained for her blood, and she was found to have a blood alcohol content, of 0.258. She was incredibly intoxicating, putting the community at risk, and is now drinking on bond. And as the court correctly pointed out, having a 13-year-old child flow into that Soberlink. I do not think she is in a position where she's capable of making good decisions. And I do not think that she is a risk the community can tolerate. I'm asking both the bond, hold her without bond, deny her a release.
Anything else, Ms. Carter?
Your Honor, the only other thing I would say is I do think it would be adequate to protect the community if she's not driving, if she has a SCRAM, if she's in treatment, especially if she can't leave.
I can't trust her. I'm just going to be upfront. It is going to be very hard for me to trust somebody that this court releases on a Soberlink, can't comply with the Soberlink, drinks, and then to try to save herself because she knows she has to do the confirmation below. She puts a child to do that. Incredible. I will adjourn our probable cause conference May 14, 2026, 9 a.m. I'll also adjourn, since there's no admission or anything regarding the bond violation. I'll adjourn the bond violation hearing to also that date. At this point in time, the defendant's bond is revoked. Defendant's remanded to the Washington County Jail.
Judge Simpson's decision rests primarily on risk and trust, not punishment for the underlying charge. Ms. 3 is accused of operating while intoxicated as a third offense, with the prosecution reporting a blood alcohol content of 0.258, prior offenses from 2011 and 2016, multiple reports of dangerous driving, and a crash. Those allegations already create a substantial public safety concern. Drinking while released and allegedly using a child to defeat Soberlink suggests that the existing bond conditions were not merely missed, but intentionally undermined. The defense presented meaningful mitigation: intensive outpatient treatment, individual therapy, daily recovery meetings, psychiatric care, domestic violence trauma, and the responsibilities of raising 2 children. But mitigation must answer the court's immediate question: can this person be trusted to obey conditions outside custody? Judge Simpson expressly says he cannot trust her, which defeats the argument that another monitoring device alone would adequately protect the community. Importantly, the violation hearing is adjourned because there has been no admission or evidentiary determination. Nevertheless, bond can still be revoked while that issue awaits resolution, because release decisions are preventive and risk-focused. Was remand necessary? Or could direct release into a locked inpatient program have managed that risk? The defense offered that alternative, but the alleged deception appears to have outweighed it.
Court calls the case, People versus Justin Thomas.
Bring it over for the people in your record.
Brian Bowling on behalf of Mr. Thomas, judge, who is approaching. State your name for the record, please, Justin.
Justin Thomas.
Judge, when it comes to the the probable cause conference, I'm asking that we adjourn that. I'm still trying to get some discovery video specifically. And then I'm prepared to address what you're holding in your hands.
Yes, go ahead and address that.
All right. So he didn't report for the Soberlink until today. He has it currently right now. He went over to community corrections before coming here. The reason for him not having it before was that he was unable to pay for the shipping costs to have it sent to him directly. He has no resources financially at this point in time, Your Honor. But he does have it now. He lives in Pinckney.
St. Clair Shores.
Oh, I'm sorry. I thought I've been addressing Pinckney. All right. He lives in St. Clair Shores. I'll have to get an updated mailing address for you.
Well, then he needed
So
to
it's
find,
even better, I guess, but for my
right, but he needed to find a way down here. He doesn't get to.
And Mr. Thomas and I had that discussion, Your Honor, that
He's been released and almost for a week. He
did not have transportation to get here, Your Honor. It was a
walked by that time.
a very difficult situation getting him here today once the Zoom grant was revoked. But he did make it here today. He has the Soberlink. He did test the community corrections today. To my understanding, that was negative. And he's prepared to comply with this court's bond order for purposes of testing moving forward, Your Honor.
Well, it can't work. This wasn't even just an issue of not having the shipping. He wasn't calling people back. He wasn't completing his whole intake.
We did complete, my knowledge, Your Honor. He wasn't returning calls. Again, like I said, Mr. Thomas and I discussed that. I don't expect the court to have any further problems with him at this point in time. He does have the device. He's holding it here. You got to return calls when people.
Why weren't you calling them back? I mean, I don't understand this.
He works nights, Your Honor. I think when he was trying to make the return calls, there was times where community corrections was closed. Again, that's something we discussed. There is a bit of may we approach briefly?
May.
Okay, thank you. Thanks for the bench conference, Your Honor. I have nothing further to add on the record at this point in time. Like I said, based on him having the Soberlink now, I would ask the court to continue his bond and then new probable cause conference date, or would be so willing.
Probable cause conference will be set for May 21st, 2026, 9 a.m. At this point, since he's on it, I'm not going to do anything. But I want you to understand something, young man. If you miss one blow, I'm not hearing any uses from you.
Oh, no.
Am I clear?
Yeah, it's pretty clear.
Bond will continue.
Thank you, Judge. Outside real quick, I want to get that new address.
These back-to-back hearings show how Judge Simpson distinguishes between a bond failure that destroys trust and one that may still be corrected. In Miss 3's case, the court confronted allegations of drinking while on bond and intentionally defeating Soberlink by having a child perform the confirmation blow. Combined with the alleged 258 blood alcohol level, dangerous driving, a crash, and 2 prior intoxicated driving offenses, The judge concluded that community safety could no longer depend on voluntary compliance. Her bond was revoked, although the alleged violation itself remained scheduled for a hearing because she did not formally admit it. Mr. Thomas also failed to satisfy an alcohol monitoring requirement promptly. His attorney blamed financial hardship, transportation problems, night work, and difficulty reaching community corrections. Those explanations were weakened by evidence that he had not returned calls or completed the entire intake process. However, he appeared in court with the device, had reportedly tested negative that day, and was prepared to comply moving forward. That gave Judge Simpson a concrete reason to continue bond rather than revoke it immediately. The contrast is the legal lesson. Judges often evaluate not only whether a condition was violated, but the nature of the violation, the defendant's response, and whether future compliance remains believable. Financial or logistical problems may be curable. Conduct suggesting deception and continuing danger is far harder to overcome. Do you think the different outcomes were justified, or should Mr. Thomas also have faced immediate detention after ignoring calls? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.